All right, we are here on case 21 CF 867, State of Florida versus Crystal Smith. Who do I have appearing on behalf of the State of Florida?
Jennifer Duncan.
And on behalf of the defense?
Matthew Kuchergis with my partner Elizabeth Betsy White.
All right. And Ms. Smith is also present. We're set for jury selection to begin on Monday. However, I was notified that there had been a change in circumstances, and we added the case to the calendar for this afternoon. So with that, Mr. Kuchergis, do you want to update the court on where things are?
I will, Your Honor. The state and the defense have been talking for a little while regarding a resolution of this case short of trial. And through those efforts, we've arrived at a negotiated disposition whereby Ms. Smith will be entering a plea of no contest to the count charged in the information tampering with evidence. The negotiated disposition entails Ms. Smith being adjudicated guilty of the charge to be sentenced to 5 years of probation with a special condition of 30 days in the St. Johns County Jail. Defendant is eligible for early termination of probation after 3 years, and there will be standard court costs and fines assessed, as well as a $100 cost of investigation to the St. Johns County Sheriff's Office and a $100 cost of prosecution to the State Attorney's Office. With that being said, Your Honor, I have a plea form that's been executed by Ms. Smith, myself, and Ms. Duncan. And if I may approach, I could tender that to Madam Clerk.
You may. You can approach with your client up here to the railing. Ms. Duncan, if you'll come forward as well. Ms. Duncan, you just heard Mr. Kuchergis state the terms of the plea agreement. Is that the plea agreement that the state has negotiated with Ms. Smith?
Yes, Your Honor.
And I see that the Bailey family are all present, as well as some other friends and family members. Are they also in agreement with this disposition? Are they requesting for the court to accept this proposed disposition?
Yes, Your Honor.
All right. Any other matters that we need to address at this time before we begin?
No, Your Honor.
All right, ma'am, if you'll raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, state your name.
Crystal Smith,
How old are you?
38.
How far did you go in school?
I graduated high school.
Are you able to read, write, speak, and understand the English language?
Yes, sir.
Are you under the influence of any medication, drugs, or alcohol?
No, Your Honor.
Have you ever been diagnosed with a mental health condition that might affect your ability to understand what's happening right now?
No, Your Honor.
Your attorney has informed me that you wish to change your previously entered plea of not guilty and enter plea of no contest to the charge of tampering with evidence. That is a third-degree felony, which is punishable by up to 5 years in prison. Pursuant to the plea agreement, I would adjudicate you guilty of that offense, place you on 5 years of probation with the condition that you serve 30 days in the St. Johns County Jail. You have credit for 1 day that you've already served. You may apply for early termination of your probation after 3 years have been served. You would also be required to pay standard court costs and fines plus $100 cost of investigation and $100 cost of prosecution. Is that your understanding of the plea agreement?
Yes, Your Honor.
Is anyone forcing you or threatening you in any way to get you to do this?
No, Your Honor.
Has anyone promised you anything in exchange for your plea?
No, Your Honor.
I have a document here. It's a plea form. It has the State of Florida versus your name and our case number. On the second page of this document, above the word defendant is a signature. Is that your signature?
Yes, Your Honor.
By signing this document, are you indicating to me that you've read this document, that you've also had a chance to discuss it with your attorney?
Yes, Your Honor.
There are a number of rights I want to make sure that he went over with you that you'll be giving up if I accept your plea today. You have the right to a jury trial. During that trial, you're entitled to be represented by an attorney. If you could not afford one, I would appoint one for you. You and your attorney can sit quietly throughout that entire trial and require the state of Florida to prove this charge beyond a reasonable doubt. You also could have testified during that trial. You could have presented evidence during the trial. You could have compelled witnesses to come in and testify on your behalf and cross-examined any witnesses that might have been called against you. And you could have appealed your conviction and sentenced to a higher court. You understand that once I accept your plea today, there will not be a trial and you'll be giving up all of those rights?
Yes, Your Honor.
Have you had sufficient time to speak with your attorney about any possible defenses that you might have raised to this charge?
Yes, Your Honor.
Do you need any more time to speak with your attorney before I accept your plea?
No, Your Honor.
Are you satisfied with his representation of you?
Yes, Your Honor.
Did your attorney explain to you that if you were not a United States citizen, that entering this plea could subject you to being deported from the United States?
Yes, Your Honor.
And did he also explain to you that if you have ever been convicted of any type of a sexually motivated offense, that entering this plea could subject you to being involuntarily civilly committed?
Yes, Your Honor.
State, have you disclosed all the discovery in this case?
Yes, Your Honor.
And is there any DNA evidence known that might exonerate her?
No, Your Honor.
Well,
Juries?
Your Honor, that's been the subject of some prior proceedings before his honor, as well as the perpetuation of the testimony of FDLE agent Brooke Hoover, for which Ms. Smith was present. I know that the question about DNA that could exonerate is generally directed to different scenarios than we have present here. There's an argument that it could exonerate. What I would tell the court is we're fully aware of what the status of the DNA evidence in this case is, and despite that knowledge, we intend to proceed with the entry of the plea.
Have you received all of the discovery in the case and discussed it and gone over with your client?
I have.
Statement of factual basis, please.
Yes, Your Honor. On or about May 9th, 2021, in the county of St. Johns, in the state of Florida, the defendant did alter, destroy, conceal, or remove any record, document, or thing, to wit, a pair of jeans, with the purpose to impair its verity or availability in a proceeding or investigation, knowing that a criminal trial, proceeding, or investigation by a duly constituted law enforcement agency of this state was pending or was about to be instituted, contrary to court statute.
Any objections or exceptions to the factual basis?
No objections or exceptions for purposes of the plea, Your Honor.
I do find sufficient factual basis for the charge of tampering with evidence. Ms. Smith, I accept your plea. I find it's entered into freely, voluntarily, and intelligently, that you are coherent and alert, and that you understand the nature of the charge and the consequences of your plea. Before I impose sentence, are there any victim impact statements that will be presented today?
There is one, Your Honor. I also have the, do you want the score sheet now or later?
Yes.
Okay. I have the score sheet prepared here now. I've prepared a copy for counsel. This is the only thing on the score sheet, bringing her total number of points to 16. And as Your Honor knows, that means that the court must sentence an offender to a non-state prison sentence when their points are below 22, and that was taken into account by the state. I'll pass that.